This is Let Your Voice Be Heard, right here on WHCR 90.3 FM, the voice of Harlem.
WHCR 90.3 FM, New York.
If you don't know what that is, that's Money by Pink Floyd. And that's what we're talking about today. We're talking about money and corruption and influence. And now we're talking about how money and corruption and influence in elections is bleeding into the judicial branch. Today I'm going to be talking about a case that is being heard by the Supreme Court on Tuesday, January 20th. The name of the case is Williams U. Lee versus the Florida Bar. And the issue that the Supreme Court is going to be deciding is whether state judges that are running for office have the same campaigning rights as politicians. Now, let me give you some background. Lynell Williams U. Lee, she was a candidate for county clerk judge in Florida, and she was running for county court judge in Hillsborough County. She signed a campaign fundraising letter in which she announced her candidacy, and then she personally requested campaign contributions. The letter was then mass mailed out to voters, and it was posted on her campaign website. Subsequently, Ms. Lee was disciplined by the Florida Bar Association and by the Florida Supreme Court. Both the Florida Bar Association and the Florida Supreme Court said that by sending out this mailer directly soliciting campaign contributions, that she had violated the state's Code of Judicial Conduct. In Florida, as in 30 of 39 states that elect their judges, there's a rule that prohibits any candidate from judicial office from personally soliciting campaign funds or from sending out this kind of direct solicitation. The reason for this is to prevent the appearance or the risk of corruption. Instead, judicial candidates are required to set up separate campaign committees, and they are allowed to send out fundraising requests, but it's done by the campaign committee and not by them. So, what happened? Ms. Williams U. Lee said that under the new Supreme Court laws that have come into effect, Supreme Court interpretations of the First Amendment, Citizens United, and McCutcheon from last year, that these ethical rules that prohibit from directly soliciting campaign contributions violate her First Amendment right to free speech. She then sued, and now the case has gone all the way up to the Supreme Court. And the Supreme Court is going to decide whether states that elect some or all of their judges may prohibit candidates from directly soliciting campaign contributions. More specifically, they're going to decide whether this rule of judicial conduct, prohibits candidates from judicial office from soliciting these funds, violates the First Amendment. Now, I should point out, if it's not already clear, that the issue is not about whether judges and their challengers may raise campaign funds. As I said already, they can already do that through campaign committees. It's about whether they can now do that directly. Now, we have to look at some law here. Break it down for you really, really simple. This rule, the judicial rule of conduct that prohibits this kind of solicitation, the Florida Bar says that it's necessary to ensure that there's impartiality of judges, to prevent the appearance of corrupt influences, and to ban any quid pro quo link between a campaign contributor and a judicial candidate. In addition, the Florida Bar says that the rule is narrow enough in order to meet the requirements of the First Amendment, since the Supreme Court in the past has consistently recognized that states do have a compelling interest in maintaining public confidence in the integrity of the judiciary and judicial elections. However, there's 3 cases that are going to come into play. There's a 2002 case that's known as Republican Party of Minnesota versus White. In that case, in a Supreme Court opinion that was written by Justice Scalia, the Supreme Court struck down a restriction on speech in judicial campaigns, and they found that a rule which prohibited judicial candidates from announcing their positions on controversial issues actually violated the First Amendment. In addition, more recently, under the Roberts Court, in the name of freedom of speech, the judges and the court has expanded the ability of corporations and unions to spend funds directly on elections. That's Citizens United. And less than a year ago, they invalidated a limit that Congress placed on the overall amount of money that individuals can spend in a 2-year federal election cycle. That's McCutcheon versus FEC. So ultimately, this is a really big deal because the crisis of money in politics, as we all know, is being played out all over the country. And you're essentially seeing a situation where people can buy their legislature. But now people are starting to realize that it actually costs less money to buy a judge, and you get more influence when you do it. So I'm hoping that the Supreme Court is actually going to see this for what it is, and that they're going to say that states do have a compelling interest in maintaining the public confidence in the integrity of the judicial system, and they are going to say that this rule is narrowly drawn enough in order not to violate the First Amendment. However, I do not have much confidence in the Roberts Court, and I ultimately am very concerned and very nervous about this ruling. And now, on the other hand, some people will say, well, if they can already get money through their campaign contributions, then what does this matter? But at the same time, personally, I just feel that there should be that degree of separation between you and your contributors, and that's the purpose of the campaign committee. And you still get your freedom of speech. You can still, go out there and collect as many contributions as you want. You just can't do it directly. And I think that is very important in maintaining public confidence in the judiciary. So we'll have to wait and see on the Supreme Court, but I really don't have much confidence in them.
I don't either. And because of their history and what they've shown in the past, we shouldn't have confidence. So we'll see how this plays out. Thank you for that, Alyssa. And we'll continue following the story. And another thing that we'll continue to do is we'll continue to let your voice be heard every Sunday right here on on WHCR 90.3 FM, the voice of Harlem, from 11 a.m. to 1 p.m. But we have to say goodbye. We're going to say goodbye for now, but we'll be back next week. And make sure you subscribe to our podcast via iTunes so you don't have to miss out. Later, guys.
Hey, I can be the answer. I'm ready to dance when the vamp up.
WHCR 90.3 FM, New York.